Introduction. The rule of Civil Procedure 12F permits a court to strike from a pleading in an insufficient defense or any redundant, immaterial, impertinent, or scandalous matter. Although motions to strike are generally disfavored, they are appropriate when defenses are legally insufficient or prejudicial to the moving party. The court should be particularly concerned about defendants' unified defense strategy, where joint counsel represent parties with inherent conflicting interests. Many of these affirmative defenses are legally impossible for one defendant, but potentially available to the other. Yet defendants fail to specify which party is asserting which defense. This unified approach obscures critical distinctions between municipal and individual liability, creating precisely the unfair surprise that pleading standards are designed to prevent. So part of this is you need to be neutral in what you're pleading. You want to point out we're talking about the rules. You're arguing procedure, and that one defendant potentially has these defenses, but they're not available to the other defendant. So you have to. What I've seen in a lot of pro se pleadings is it's all emotion and looking at the pure legal matters. They can't detach a little bit from it so that they can talk about how the rules apply, how the law applies, and that's really critical to be able to make any sort of court filings and procedures where you're going to persuade a judge.
And defense counsel is going to throw anything and everything in the book at the pro se because they want to wear the pro se down. So they're going to plead even legally foreclosed defenses or defenses that are irrelevant to the matter because they want to overwhelm the pro se and exhaust the pro se.
And I think that works as a double benefit for the law firm as a whole, because not only is it by default going to wear down and frustrate the pro se, but it also allows, if it's two law firms, they can use the same strategy, and both law firms can leverage these dilatory tactics, these law warfare through attrition tactics, so that both sides get maximum amount of money from both of their clients. So there's not an incentive for general practitioners to be efficient in law because there's less money in it. And so that's my view on that.
So my point is that use the 12F to our advantage by pointing out the legally foreclosed defenses that the defense is attempting to raise. Why are they legally foreclosed? Cite the cases that say that they are legally foreclosed and, fight the defense with everything you've got.
Yeah. All right. So now we're on to section 2. Now you'll see these numbered 1.1 and 1.2 are all under introduction. Now 2 is defendants' pleadings create substantial prejudice and delay. 2.1, defendants' conclusory defenses create an unfair discovery imbalance, requiring pro se plaintiffs to provide factual support for her claims while leaving her unable to anticipate or prepare for defenses that lack any factual foundation. This asymmetry prejudices the plaintiff's ability to effectively litigate her case. 2.2, as a pro se litigant, plaintiff faces particularly hardship responding to 20 inadequately pleaded defenses while opposing institutional defendants with taxpayer-funded counsel. Defendants exercise all 20 affirmative defenses could add a year or more of motion practice to the case before reaching the merits. 2.3. Several defenses serve merely as pretexts for intrusive discovery into irrelevant matters. Heck, enables criminal history exploration despite no convictions. Unclean hands invites invasive personal inquiries, and after acquired evidence wrongly suggests employment-related document requests. 2.4. Defendants' joint representation creates irreconcilable conflicts in their defense strategy. The city must portray as acting outside of policy to avoid Monell liability, while must demonstrate he acted reasonably within official capacity to claim qualified immunity. These contradictory positions assert without specifying which defendant relies on which theory, prejudice plaintiff's ability to prepare proper responses and discovery. There's something you wanted to add to that?
No, I can't.
Okay. Section 3. Several defenses are legally improper in 1983 actions. Defendants assert good faith immunity and comparative fault explicitly barred under Owens, which prohibits municipalities from claiming such protections in Section 1983 actions. 3.2. Defenses like unclean hands, after acquired evidence, and Heck v. Humphrey have no application to the constitutional claims at issue. Defendants improperly invoke the Mississippi Tort Claims Act and adequate state remedy barriers, standards inapplicable to federal constitutional claims under Section 1983. 3.4. This mixing of inapplicable tort, employment, and criminal law defenses with legitimate Section 1983 defenses creates unnecessary complexity, risks misleading jury instructions, and potentially confuses constitutional standards with incompatible tort doctrines.